subsequent to the Ashcroft case, and actually subsequent to a couple of the other cases that we'll also look at in a moment, Congress did revisit this issue of virtual child pornography in something called the PROTECT Act. And this was the PROTECT Act of 2003. And so these portions of the previous law involving virtual child pornography were amended to try to address some of the concerns that the Supreme Court had. And if you look at the statute now, it defines child pornography, and it's got this definition here of various means of reproduction, sexually explicit conduct. And here's how they try to make it particular. Involves the use of a minor, so an actual child, a digital image, computer-generated image that is or is indistinguishable from a minor engaging in sexually explicit conduct. And this is really trying to, I think, get at Justice Thomas's hint in his concurrence that if the technology gets better, the statute could be upheld. And the visual depiction is created, adapted, so on, to appear that an identifiable minor, or the depiction is created so that it appears to be an identifiable minor. And this is really getting at this idea of morphing, that there is a minor, and the picture is then kind of changed to make it sexually explicit. The statute defines identifiable minor, and you can kind of look at the definition there. One of the kind of key pieces in this definition of identifiable minor, and we'll see this again next week when we talk about New Jersey law on virtual child pornography. There is a New Jersey Supreme Court case on this under the New Jersey statute. And, one of the questions is, well, what would a prosecutor have to prove to, show that it's an identifiable minor? And so here the statute says it's recognizable as an actual person, but you don't have to show who the actual minor was. So for example, what if somebody just grabs a random image of a child off of Google Images and, manipulates that to make it appear sexually explicit, and then kind of trades it or sells it as child pornography, and there's no way to really trace who the original image was of, it still would satisfy the statute. So indistinguishable, notice that definition as well, because that's an important definition. And I think you can see by reading it, it's Congress is sort of struggling with a way to kind of define this. Indistinguishable means virtually indistinguishable. An ordinary person would conclude that it's an actual minor, and it's trying to exclude drawings, cartoons, sculptures, paintings, and so on. So those are going to raise. So this part of the statute is still in force, and these modifications are still in force. There are issues about how they get applied, what that means, and we'll look a little bit more at that piece of it under state law next week. Okay, and this leads us now to a discussion of the Communications Decency Act. So the Communications Decency Act was a big deal in the late 1990s. It was another kind of early effort by Congress to deal with a range of issues around pornography, obscenity, and the like on the internet. And it was kind of within the internet law community at the time, another one of these big causes. I mean, the sort of the copyleft, the cyber exceptionalist elements of internet law at the time were really outraged by this statute, and really felt like it was a significant impingement on free speech. And of course, it gets challenged in various ways, including this challenge by the ACLU, which gets up to the Supreme Court. So what the statute did, in kind of the parts that we're looking at tonight, it's about the ability of young people, of children, to access pornography and other types of material of that sort online. Now notice this is not a child pornography statute. It is a statute that involves any kind of obscene material that a minor might be able to access. So it prohibited transmission of obscene or indecent material if the transmitter knew that the recipient was under 18, Same thing about sending or displaying that kind of material. It had some defenses built in. So, if you took some good faith actions to restrict access by minors, and it created a safe harbor by saying if you require credit card verification or an adult ID number or code to verify that the user is an adult, then that could be a safe harbor. So you can see what this statute's trying to do is trying to say to any provider of internet content that if there's any chance that the material is going to be obscene and is going to be able to be accessed by a child, which really you can't know for sure who's going to access your stuff on the internet, then you would have to have some kind of means of it was really trying to force some kind of means of verification. And so here again, the court finds this part of this statute unconstitutional. And now you have a majority opinion by Justice Stevens. As I mentioned, Stevens is a strong defender of First Amendment values. And Stevens says it's a blanket restriction on certain kinds of speech. It's not, in his opinion, just a time, place, or manner restriction. Notice this quote, and this is where a place where U.S. Supreme Court law is perhaps at the height of what we called cyber exceptionalism in our module on our first module on internet governance. So notice this quote: "Never before or after have the vast democratic fora of the internet been subject to this kind of government supervision or regulation of the same sort that attends the broadcast industry." And what he's referring to there are the various kind of decency rules, censorship rules in public television and public broadcasting. Stevens says the internet is not as invasive as radio or television. Radio or television, you turn it on and it's on. And it's on in the family room, and if one of the prohibited bad words comes over the air, if there's an F-bomb on your public television show, all the kids will hear it. If there are naked people on your broadcast television show, the kids will see it. He says not so with the internet. Now, I think this is a piece of this case that is perhaps a little bit frozen in amber from 1997. I'm not sure that anyone would really agree that the internet is not as invasive as radio or television today, because we all have the internet in our pockets, in our phones, including our kids. And you might say, well, don't give your kid a phone. If you have a young teenage, preteen kid, they're going to have a phone, and it's partly because you're going to feel safer if they're out somewhere and they have a phone and so on. But we all know we all have the internet. It's totally accessible. But this is 1997, and it was a little bit of a different world. All right, so Stevens also says that the statute is not specific enough. The terms aren't well defined. It doesn't really follow the Miller test for what might or might not be obscene. He suggests that the safe harbors and the good faith defenses are unfeasible. They're too expensive. The technology to implement them doesn't really exist in any sort of meaningful way. That piece of this case is kind of interesting. To some extent, that's probably still true. If somebody wants to get around a verification technology, they probably can get around it. To some extent, it's not true. I mean, people have talked about biometrics, for example, having some kind of requirement for a fingerprint reader or something along those lines for certain kind of sites. It certainly is technologically feasible, but it involves expense and transaction costs, the time and effort to do it. And, note, again, this kind of strong piece of cyber exceptionalism. Stevens says the CDA threatens to torch, great word from Justice Stevens, to torch a large segment of the internet community. And ultimately, Stevens says this statute could only be upheld to the extent it's really targeted toward the kind of obscene speech that you could regulate under the Miller test. So again, here we have a robust debate among members of the court with some concurrences and dissents. So we have a concurrence and partial concurrence, partial dissent from Justice O'Connor. Notice you've got Stevens, kind of the very strong First Amendment view. You have O'Connor, as she often does in these cases and as well as in other kinds of cases, kind of occupying this middle, trying to find some kind of middle space. And O'Connor is looking at this as a kind of zoning regulation. So O'Connor says you can have zoning regulations that deal with obscene material or a material that is kind of questionable. So, even if it might not be possible in a particular area to completely ban all pornographic literature or pornographic movies under the Miller test, you could zone and say you can only buy those things in the red light district. And, those kind of zoning regulations, generally the court had upheld, unless they're, really just kind of subterfuge for banning the material, but generally the zoning regulations are upheld. But notice again a really strong element of cyber exceptionalism in this case here from Justice O'Connor. And O'Connor says cyberspace, the electronic world, is fundamentally different. Cyberspace allows speakers and listeners to mask their identity. And so what she's saying here is, you really can't do this kind of zoning in cyberspace. It's just not really possible to say, 42nd Street is the red light district. Of course, now it's the Disney district, but, years past, 42nd Street is the red light district, and this is the family district. She says you can't do that online. But note this. She does say cyberspace is malleable. It could be feasible in the future to create adult-only zones if the technology develops to allow that. Again, this case, 1997. So she says, with existing technology, the Communications Decency Act should have been upheld in the narrow circumstance where the party initiating the communication knows that all the recipients are minors. When would that happen? I mean, it might be in a particular chat room or a particular email, or something along those lines, but in that narrow case. But notice that O'Connor does leave open the possibility that if technology makes that kind of zoning possible, maybe the statute could be constitutional.